Section 17 of the Indian Contract Act 1872 states that mere silence as to facts is not fraud. However, here are a few exceptions. I am Sanika and I will begin with the first exception, duty to speak. Mere silence is not fraud unless there is a duty to speak. We must note that this duty is a legal duty and not a moral duty. Duty to speak can arise in case of a fiduciary relation. Example of a mother selling a car to her daughter. The mother is aware of the mechanical issues with the car. The school does not to disclose the same as it may affect its resale value. This amounts to fraud as the daughter is likely to rely upon her mother due to the fiduciary relationship between the two.
In the absence of any such relationship, there is no duty to speak. This was articulated in the case of Aji Ahmed Yar Khan versus Abdul Ghani Khan, where the plaintiff spent a sum of money on the engagement of his son. Later, he discovered that the girl suffered from epileptic fits and broke off the engagement. He sued the other party to recover compensation for the loss suffered on account of the deliberate suppression of a vital fact. Since there was no fiduciary relationship between the two parties, the plaintiff was not entitled to recover any compensation. However, the engagement was held to be voidable by reason of misrepresentation. Duty to speak also arises where one of the parties has no means of discovering the truth and has to depend on the good faith of the other party. For example, a contract of insurance where the insurer knows nothing about the life or circumstances of the insured and has to depend on the disclosures made by them. Hence, it becomes the duty of the insured to disclose all material facts affecting the risk cover. This is why contracts of insurance are contracts oberena fides, which means contracts of utmost good faith. In P. Sarojam versus LIC of India, the assured, despite suffering from a serious heart ailment for several years, gave false answers in the proposal form in order to induce the LIC to accept the proposal. Within a few months, he died of a heart ailment. The policy was held to be voidable and the LIC was entitled to repudiate the policy and decline the payment of claim.
Mere silence does not amount to fraud unless there is any legal obligations to disclose the fact. The general principle states that silence regarding a fact that may affect a person's willingness to enter into a contract does not constitute fraud. For instance, A is a shop owner and B is a customer. If B purchases a shirt from the shop and later finds it torn, he cannot claim fraud simply because the shopkeeper remained silent about the defect, especially if the shopkeeper was unaware of it. The shopkeeper's silence does not mean he has deceived the buyer. Here applies the principle of covert emptor, let the buyer be aware. It is the responsibility of the buyer to check the goods before purchasing it. This principle applies in movable properties. However, different rules apply in unmovable properties. Under Section 55 of Transfer of Property Act 1882, the seller has a legal obligations to disclose all the material defects in his property that he is aware of and that the buyer could not discover it through reasonable diligence. For instance, if A owns a property with structural defect or defective title and sells it to B without informing him about this condition, then A has committed a fraud. Here, the silence is considered deceptive as law imposes the duty on the seller to disclose any facts regarding the property before the contract. Similarly, buyers also have a duty to disclose important information if they know any. According to Section 17, Subclause 5 of the Indian Contract Act 1872, such an omission where one party deliberately withholds information that could have influenced the other party's decision is recognized as fraud.
Change of circumstances refer to situation where significant development occur after representation but before finalization of a contract. Changes materially alter the condition or the fact on which the contract is based, then the party aware is under duty to disclose them to the party involved. Failure to do so can amount to fraud as it misleads the other party to enter into a contract based on outdated or inaccurate assumptions. This principle ensures that contracts are entered into with transparency and fairness, preventing one party from gaining an unfair advantage by withholding material information. In the case of Rajagopala Iyer versus South Indian Rubber Works, the company issued a prospectus inviting people to subscribe to its shares. After issuing the prospectus, significant changes occurred in the company's financial position and directorate. These changes were not disclosed to the investors and this amounted to fraud. The court said that the contract was voidable. A agrees to sell a house to B, claiming it was in perfect condition. But before the sale, a storm ruins the roof of the house. A notices this but remains to stay silent. This action of A amounts to fraud as it misleads B into believing that the house was in perfect condition.
When making a contract, it's important to be honest. But what happens when someone tells you something that is true but leaves out important information? In contract law, half truths can lead to misinterpretation, which can cause legal issues. A job applicant says that they worked at a big company, but doesn't say that they only worked there for 2 weeks as an intern. This accounts as fraud as they lied about their position at the interview. In Demers vs. Hallett of 1866, the seller told the buyer that the farms were fully rented out, but failed to mention that the tenants would be leaving soon. If someone chooses to speak, they have to give all the information, or this can lead to misinterpretation. If the half-truth is considered as misinterpretation, the other party can take legal action, such as cancelling the contract or taking monetary compensation for the problem caused due to the information. In contract law, silence can sometimes be as deceptive as a lie. While there is no general duty to speak, staying silent when there is an obligation to disclose important facts can lead to fraud or misinterpretation. Half-truths are equally dangerous, as they give a false impression while appearing truthful. If circumstances change, failing to update information can also mislead the other party. Contracts should be based on honesty, fairness, and full disclosure.